Welcome to Litigation and Capital.
Hey everyone, welcome into an all-new episode of Litigation and Capital with Steven Mirsky. I am your host, Mike Leon. Steven here is the founder of Mirsky Corporate Advisors, and in each episode, he breaks down the high-stakes legal issues affecting companies, maybe like yours, those earning $10 to $100 million a year, so you can turn the complexity into leverage and protect what you've built. And in today's episode, we're going to be discussing and unpacking what really happens when a lawsuit hits your company. Step by step, from filing to resolution, Steven's going to break it all down. Steven, it's good to see you as always. Let me ask you, when a civil case begins against a company, what documents start this process and the action?
Thanks, Mike, for having me. And, when a civil case begins, usually I get a flurry of emails and text messages saying what the F happened, how could this guy do this to me, so on and so forth. But what they typically receive is a fat packet from a process server or a fat packet that is mailed to them by certified mail. And inside of that fat packet, you have a couple of things. The first is the complaint. The complaint is the document that says, hey, I'm suing you. This is why I'm suing you. And these are the reasons why I'm suing you. The next thing is the summons. The summons is from the court. It's issued by the court, meaning that the court has to sign it before you can send it out. And it says, hey, you have 30 days, or in some cases 40 days, to respond to this. And if you don't, you risk a default judgment. And then there's a variety of other things that come in with it, depending on which court you're in. Let's assume for a moment we're in California State Court. You're going to get an ADR packet. ADR is alternative dispute resolution. So, hey, if you don't want to duke this out in court, here are some other mechanisms we can use to resolve this dispute. And then you'll also get a hearing date for a case management conference. A case management conference is a conference where the judge will say, all right, guys, what's the issue? Why are you fighting? And how long do you think it'll take before we go to trial?
And I'm sure there's some jurisdictional requirements that have to be met as well, right? Before the court can hear it?
Yes. So it's very important to know which court we're filing in, because every court has different rules. We have state courts, just broadly speaking. We have state courts, we have federal court, so like the district courthouse, and we have bankruptcy court, which is also a federal court, but a subsection of federal law. And then on top of that, you've got the appellate courts and the Supreme Court, both in your state and the federal. Each of these things have different jurisdictional requirements. But for today's purposes, we're just really going to look at federal court and state court. So a state court has general subject matter jurisdiction based on your location. So what is subject matter jurisdiction? Subject matter jurisdiction is, hey, does this court have the right to hear this case? And so state courts are courts of general jurisdiction, meaning that they want to take care of everybody that is inside of their zone of influence, for lack of a better word. So if I'm in California, I'm a California citizen, I'm going to sue you. I'm going to bring a case in at California State Court. But which California State Court? That ties to less about subject matter jurisdiction, but another type of jurisdiction, which is called personal jurisdiction. Federal courts, on the other hand, are courts of limited jurisdiction. Congress does not want them to hear every case. So a federal court has what's called original jurisdiction and diversity jurisdiction and supplemental jurisdiction. So what is that? Original jurisdiction is if the claim that we're fighting about arises out of federal law. So did I violate a patent statute? Did I violate a trademark statute? Is it, a racketeering, some other statute that is directly from a code of the United States? If the answer is yes, okay, we've got original jurisdiction, we're good to go. Diversity jurisdiction is where the court looks at the parties who are involved in the lawsuit, and it says, Are each of these parties completely diverse from the other party? That's prong one. The second prong is the amount in controversy greater than $75,000? So if you're just disputing something for, like, let's call it 20 grand, first of all, you probably shouldn't be bringing a lawsuit to begin with. But let's say you did, the federal court's going to kick it out, even if you had complete diversity. So, and diversity jurisdiction, it looks at the citizenship of all of the parties. So what's a citizenship of a corporation? The citizenship of a corporation is A, where it was incorporated, and B, its principal place of business. So if I'm a corporation, a Delaware corporation with a principal place of business in California, I am, for diversity purposes, a citizen of Delaware and California. But what happens if I'm an LLC? If I'm an LLC, I take the citizenship of every member of the LLC. Well, if I'm suing an LLC, how do I know who is every member? Well, oftentimes you don't. And that is a challenge when it comes to litigation. And so when you're looking at where you're filing and where to go, you really want to answer these questions beforehand, because no one likes to litigate jurisdiction, like subject matter jurisdiction issues in court. And then the last thing is supplemental jurisdiction. Supplemental jurisdiction in a federal case is, hey, I have state law claims that are attached to my federal claims. Can the federal court hear this? And the answer is yes, so long as it first has diversity jurisdiction or original jurisdiction. Well, what happens if a court doesn't have federal question jurisdiction, diversity jurisdiction, or supplemental jurisdiction? Well, then the court can't hear the case, period. And between both the state court and the federal court, there's an issue of standing, and there's an issue of mootness and ripeness. So what is standing? So the standing is, hey, not only can the court hear this, but do you have the ability to bring this lawsuit? And ripeness and mootness relate to a prohibition in the Constitution that says a court will not provide advisory opinions. So there has to be a concrete and particularized injury to a party before a court can hear the case. So if there's no injury, no courts can hear it, even if some of these other factors can apply.
Steven, you mentioned when somebody gets that shiny packet, now they're being sued, right? And within there's a complaint document. So once the complaint's filed, what immediate procedural options does a defendant have? And how are those decisions made?
Well, at the end of the day, it all comes down to money. And I think emotion too. The question, I think, is, if you're the defendant, did you do what they said they did? And how much money do we want to have to fight this thing? The procedural options you have are, one, you can either answer the complaint, which says you're going to admit or deny the factual allegations that are set forth in the complaint, and you're going to raise your affirmative defenses. An affirmative defense is basically like saying, yeah, but, right? So, hey, you breached the contract. Yeah, but you guys didn't perform, right? The other option you have is you can file what's called a demur in California state court, or a motion to dismiss in federal court. There's a variety of things that you can raise on a demur or a motion to dismiss, but basically they're saying, hey, court, this complaint is defective in some manner, whether it fails to state a claim, it's uncertain, it's ambiguous, there's no personal jurisdiction, some issue, and you can attack that. Another option is to attack a subset of the issue. So forget about the complaint. Let's attack the summons. Maybe there's no personal jurisdiction, so we're going to quash the summons. If we're in California state court, maybe we'll file a motion for forum nonconvenience, try to get this case moved to a different venue. Maybe what we could do too is we could we could remove this case from state court and put it in federal court. Maybe federal law has some better issues for us. But that only works for the same reasons that we just talked about. And so there's a variety of moves that you can do at the beginning. It just depends on where you want to go. The other thing you could do is you could compel arbitration. And so we take it out of court, and then we say, you guys want to fight? Well, you have an arbitration clause in your agreement. Put up the money, and we'll start talking. So it depends. So the factors that determine where you want to go are the allegations, how well drafted is the complaint. Just because you've been sued, I find that most complaints are poorly drafted, and there's some grounds to attack the pleading, or whether you want to countersue them and say, okay, yeah, you sued me, I'm going to sue you now too. So those are your options.
Steven, I know you love getting into the weeds here, and I wanted to ask you about this rule 12-B6. What does it mean to fail to state a claim? What is that, and how high is that bar in commercial litigation?
Federal Rule of Civil Procedure sets forth the rules of duking it out in court, basically, right? What you can and cannot do. Rule 12 says, hey, look, a defendant can make a motion to dismiss the complaint for a variety of reasons. Rule 12b6 allows the defendant to dismiss a complaint for failure to state a claim. So a failure to state a claim means that either the plaintiff, so the guy that sued you, didn't state all of the elements, or didn't plead enough facts to state all the elements, or is just so bonkers, this thing does not make sense and they need a do-over, right? And so a 12b6, what does it do? A court's going to look at a 12b6 motion to dismiss, and they're going to say, hey, I'm going to assume everything you said plaintiff is true, and I'm going to disregard all of your conclusions. And so, like, let's just say, hey, they breached the contract. Well, I'm going to disregard that. Show me that they breached it. So they're going to disregard your conclusions, and they're going to make sure that you've pleaded enough facts, not for it to be plausible, but just pleaded enough facts to state a claim. And this is always a good spot to test the legal sufficiency of a complaint and sort of attack the law as the facts have been presented, because it helps narrow issues, and it also helps, I find, it helps move up settlement negotiations. So a court will analyze this, and they'll say either the complaint stated a claim or didn't state a claim. If it didn't state a claim, the court will dismiss it. It will do three things. They'll either dismiss it entirely, they'll dismiss it in part, the complaint in part, or they'll keep it in part, or they'll just deny the motion to dismiss. If a motion to dismiss is granted, the court then, typically speaking, in the Ninth District, freely grants leave to amend. So you get at least one do-over. Once you get to about 2 or 3, that's where things get a little bit dicey. And so why is it effective to do a Rule 12b6 motion? One is it helps delay things, because courts are so impacted, you're not going to be heard for a couple of months at least. 2, it'll either increase expense for the other side. How hard do they really want to sue you right now? Do they just do this for leverage, or are they actually wanting to battle? And 3, it helps you tell a story to the judge and helps color the proceedings moving forward.
Speaking of leverage, real quick, what are some of the main stages of the discovery phase here? Why does it drive so much of the cost and the leverage with respect to litigation?
Well, at the end of the day, the law is about taking facts and applying it to the law. It's a matching game. And so we need to find those facts to prove either by a preponderance of the evidence or with conclusive evidence to show that these facts are true enough to support these legal elements. And so the parties are going to go engage in litigation, not to harass and annoy, because that's illegal, but they're going to be sending things in because they have to get the facts to match what they pleaded against in their complaint. And there's only a couple of ways to do this, right? You have interrogatories, which are, hey, I'm going to ask you discrete questions, answer them. You have requests for admissions, which are really powerful tools that get you to admit or deny key components of the case. You're going to have depositions, which is where you, an opposing counsel, and your attorney are going to go into another room with a court reporter, and you're going to sit for hours testifying under oath. All of these things are expensive because they just take time. It takes time to review the documents. It takes time to sit in a deposition. And so this is really where the rubber hits the road when it comes to litigation. And everything in discovery, right, what is it trying to do? Not only is it trying to resolve the matter, it's trying to weed out extraneous issues for trial, right? Trial is only for questions of fact. So did Bob run the red light? Well, witness A said yes, witness B said no, right? That's a question of fact. We need to figure those things out. But if we can get enough facts that are, pretty much undisputed or solid enough, then the question is there a question of law, and can the judge resolve this case without a trial? And so that's what discovery is designed to do, is to make sure that the parties have enough information to make their case.
Stephen, before we wrap here, I did want to ask you, because you alluded to it earlier about federal versus state court. How do the procedural rules differ between state and federal court? And when does that removal to federal court make sense?
We could do a whole show on that, which we probably will.
That's why I asked the last.
but there are major differences in the rules from a procedural perspective. I'll just rattle a couple off that are coming to my head. Let's take service of process, for instance, right? In California, you have 30 days to respond to a complaint, 40 days if it's delivered by substitute service. In federal court, it's 21 days, right? So that right there is a key difference. Discovery-wise, I as a plaintiff can start serving discovery on a defendant 10 days after filing the complaint. In federal court, I can't do that. I can ask for a request for production of documents under what's called Rule 34, but I can't go full-blown discovery until we have our Rule 26 conference and the cases at issue. So these are some differences that play out just at the early stage of the proceedings based on where we stand, just in which court we're at.
Stephen, thanks as always for the time, insights, analysis on all this. Truly appreciate it as always.
Likewise. Thanks for having me, Mike.
And that's it for today's episode of Litigation and Capital with Steven Mirsky. You heard what the man said there. And if you want to learn more about Steven and his work over at Mirsky Corporate Advisors, do me a favor, visit MirskyCorporateAdvisors.com. A big thank you to everybody for listening to this episode. But do me a favor before you go, like, subscribe, leave a review and comment, or share it with someone who needs to hear it. I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.